I'm Derek Fahey. I'm a registered patent attorney with the Plus IP firm, and this is going to be a short video on whether or not you should file for a patent on your invention. First off, you don't need a patent on your invention to sell it, but a patent is extremely important and it does provide a huge competitive advantage. So a patent is actually a legal document that prevents other people from making, using, or selling the invention. So why is that a competitive advantage? Because think about it. If you can prevent other people from selling products that are covered under that patent, you're going to be able to exclude other people from doing that and create more market share for yourself. So if you're able to do that, and if someone infringes on your patent or sells a product that infringes on your patent or tries to, you can actually get damages in the form of lost profits if you had to sue them, or you could also prevent them from actually selling the product. So it's a huge competitive advantage. All right, now you think you want to get a patent. What do you do next? Well, some of the first steps that I recommend really are to do some just searching on the internet to see if you can find a similar product. If you can, then you may not want to file a patent application. However, on the other hand, if you think the product, you haven't found any product that's very similar, you may want to hire a professional to do what's called a patent search or a prior art search. So first off, the word prior art just means everything that exists that before a patent application is filed. So a patent search or a prior art search allows or looks for everything that exists, such as patent applications or patent application publications or patents that exist before you file your patent. Why is that important? Well, you want to analyze what's out there because you want to see if you can actually get a patent on the invention. So here's why you need to analyze that. When you hire an attorney to file a patent, they're going to file a patent with the government. They're going to prepare the application and they're going to file it with the government. After you file it with the government, a patent examiner or patent attorney at the patent office will actually examine the application and they'll do their own search. And they will look at everything that's out there and they will see, based upon the law, whether or not you're able to get a patent on the invention. If it's been existing before or there's several different laws that would actually affect your ability to get a patent, they may reject the patent application. So we recommend to do a prior art search before you actually file a patent application, because you want to know what's out there and also determine the probability of you being able to get a patent on the invention. So typically, many people will hire firms or law firms to get what's called a patentability opinion. A patentability opinion is an opinion based upon the results from a prior art search that will tell you the probability about whether or not you're going to get a patent on your invention. So before you file a patent application to try to get a patent, you should definitely consider doing a prior art search and to get a patentability opinion to see whether or not you'd be able to get a patent on the invention. The patent application process can be somewhat long and somewhat costly, so it makes a lot of sense to determine whether or not you're going to get a patent before you file it. So we typically recommend to get a prior art search and a patentability opinion before you file for a patent application. I think it's a smart business move. So hope you enjoyed the video and it was a lot of help. Check out our website for more information about who we are and what we do.